when we realize that the court is seized of the matter and that the police is looking for our client, and given the nature of our past experiences, not to mention extrajudicial killings, we decided to appear before you, Your Honor. For one reason, for our client to answer to the charges that were preferred against him in his absentia, and for him to know what is he being charged of. And the question of knowledge of what is he being charged of, Your Honor, is a constitutional question, going by the provisions of Article 10, provisions of Article 19, Article 20, Article 25, Article 48, Article 27, Article 49, and Article 50. So that, Your Honor, perhaps instead of waiting for
my learned senior colleague, and on behalf of my other colleagues in the plant, permit me to make the following request. When a party voluntarily surrenders to court, that's a party who is already willing to cooperate and to comply. Secondly, the ninth accused has appeared before you, accompanied by 4 lawyers, buttressing his innocence, and most vitally, an intent to surrender to the police as and when called upon, should he be summoned. To this end, we have no summons whatsoever. Your anticipatory bail came in first on the 18th, and to date by the DPP then, Ms. Wabo. Your Honor, out of the trust of the court, of our capacity to surrender him before you and or any other statutory organ, a fair command falls at our disposal and of this court to grant him, if at all, free bail and or bond. In the alternate, directions that as and when bond terms will be available, the same be retained as those of his co-accused, some of whom are facing heavier charges than himself. Your Honor, it was also incumbent upon us at that point to obligate ourselves in explanation. Upon being ambushed that day that he had been charged, there were prior investigations and a miscellaneous course that was closed. The record bears so. That closure indicated that the police had actually done their job and concluded, informed, and preferred a charge. If you were to be processed, which we have been always willing to do, then the same by this court's command be directed so that we know which station, if at all, you were to appear to. But this is the challenge, Your Honor. This is an accused who has been charged without summons and has voluntarily appeared. When was it to be processed prior to the charge? How was it to be processed without communication to him as to where to appear, in what manner, and in what format? Those run into what my learned senior colleague has addressed as violations. A party ought to be informed beforehand of what grievances the government or the state may have against him. Unfortunately, that was not done. Now, with far-reaching remarks being made by the DCI about his disappearance or being at large, the net effect is counsel to be cautious of his client's position and the danger posed. In sum, we do submit that Maina and Njenga, as we speak today, is a property of Nakuru, respect of criminal case number 1171 of 2023. And the DPP, as well as the DCI, can only act otherwise by leave of court. With cooperation with them, I think we've developed enough jurisprudence today on what should be done when such events happen. If there is any other charge outside this, which we are not aware of any as we speak, let us be informed so to take into the relevant organs. I've endeavored to serve the DCIO with this anticipatory bail, and consequently, the records of the file here before you are court orders which have not been valid, have not been appealed, and have not been set aside. In totality, any variation can only be by the court and or await the 20th when it's supposed to appear. But we officers of this court, all of us seated on this bench, including the DCI, and that is the honorable duty and a sacred obligation that we have discharged today. We pray that our client be directed to take his plea according to what the court may direct us hereinafter, and most importantly, to safeguard his freedom and liberty. We are willing to surrender him to any organ when called upon. That's a vow we are making to the court on his behalf, and we will diligently do that as we have done today, considering the wealth and enormous length of time we have spent before you and before the previous court. We humbly plead, Your Honor. Thank you.
Yeah, in brief, well, as myself, the submissions here permit me to add on one issue in respect as to why we have appeared before you. That this court is exercising a concurrent jurisdiction. And if we were to assume that our client was to be arrested tomorrow, and if we were to go by the dictates of the 24-hour rule, he would still have appeared before a court of law for plea taking. I do guess that the court that would have been seized of that matter would not have deferred the plea the 20th of May. It would have executed its functions as seized as then. Finally, Your Honor, the content of the anticipatory bill, the learned judge did indicate that the orders of this court were to lapse upon making a decision to charge. This is only one singular decision to charge that has been made. The DCI could be having intentions to arrest for any other reason. We submit thus that this order, due to the non-disclosure, due to the guilt of non-disclosure of the DCI, that even if there could be, by any wild imagination, any other reason to arrest, which is not known to us, then this order subsists. That the lapse is only limited to the proceedings before you. Because our client was admitted pursuant to the indications we had indicated in the application. Because in the application, Your Honor, we highlighted all these incidences that I have mentioned to you. All those raids were indicated in the application. And therefore, the learned judge considered each and every bit of it and admitted our client to anticipate. I decided to bring this in advance so that the DPP may respond. To that extent, Your Honor, that even if our client leaves this court this afternoon, he's still on anticipatory bail for any future and or subsequent intended arrest. And that is why, Your Honor, the learned judge told us to appear before her on 6th of June for a mention. We'll be having the last bite of the cherry after the DPP addresses you. If she has anything to say, she may not be having anything to say.
I always have something to say. Your Honor, for starters, as you're aware, this matter was actually an ambush because I was in the middle of my matters and a file was placed before me. As a prosecutor, we normally don't proceed without the police file. We normally don't proceed without the police file. But out of the respect I have for my colleagues, I said we can accommodate them on this distance. I've taken a look at the order that my learned counsels are referring to. First of all, it was filed in Nairobi, as they correctly put. Also, our officers, both the DCI and Prosecution, the ones who are served are in Nairobi. As we speak, I don't even have instructions from my office with respect to this matter. But given what is before court, and I do have to submit, the defense has not come to court with clean hands, Your Honor. I look at the order. If you look at number 4, they were instructed, the advocates, together with their client, to report to the DCI officers for interview and questioning on the 22nd of May, 2023. This was this Monday. Long after the anticipatory bail has been given, long after the other parties have taken bail, they never bothered to appear before the said officers. Further, I look at section 6 of the order. It also says that they need to comply if and when they are required or summoned to the police stations. They've never bothered. They know the process that is taken before an accused is charged. Currently speaking, their client hasn't been processed, even fingerprints have not been taken. So counsels decide to bypass the procedure, the proper procedure, and run to court. They cannot come to court with dirty hands. They have to come to court with clean hands. Their conduct so far, such of a person who's genuinely before court. Your Honor, from my end, I understand this is a matter that was allocated to court 8. In fact, I have no idea even how it landed in this court in the first place. I understand it has a date for 20th of June for directions, even plea, so to speak. Therefore, my submissions are that file be taken back to court 8 for directions on the date that has been fixed, that is the 20th of June. And in the interim, the defense should comply with any and every summons that are issued by the DCI officers. They are a constitutional and independent office. They are not controlled by anyone, and they follow law and procedure in their work. That is all.
So this one I'll give only to one councillor.
It's okay. We will consolidate the responses. We are careful enough to mind time and as
Your Honor, we have been accused of being guilty of appearing before you with dirty hands, and that we never complied with the orders as directed. And you know, we have given the reason as that we did not know which office to appear before. There were no summons that was ever issued to us. Until yesterday, a communique came indicating that we are supposed to appear before the Nakuru DCI office. That is one that is locally for our client. Number 2, Your Honor, that the reason why our application specifically dealt with the DCI offices is because we were not specific as to which police station was seized of this matter until yesterday, when the communique, that is on 23rd, when the communique, 24th, when the communique was issued. Number two, Your Honor, you've been told that our case has not been processed. It is equally correct that a charge cannot be preferred unless the suspect has been processed. So who jumped the gun? The defense or the prosecutor? If they knew processing was important for purposes of preparation for plea, why charge Mr. Njenga? What was the haste? What was the urgency? Urgency was to play to the public gallery, as they are doing today through that communique. Your Honor, I'm going to share with you the communique and see the title. Ex-Mungiki leader wanted. And what is the charge sheet? The first count is in a conscripted or outlawed organization. And while we shall be taking the necessary steps in terms of quashing these charges, the communique also says that it should be questioned in respect to the firearms that were allegedly discovered or recovered somewhere, and they decide to associate that somewhere with our client. He's supposed to answer to all those questions. Finally, Your Honor, if you look at the charge sheet, the individual charged with being in possession of those arms is not our client. It's a man by the name of Daudi. No link, no nexus, no association has been created in that particular charge. If, Your Honor, this is not malice that is meant to secure public narrative in respect to the credibility of our client, what else is it, Your Honor? Finally, we will be willing, Your Honor, to appear on 20th on condition that the court interprets to us the import of this order that was granted by the High Court. And this is that the order of this court shall lapse if a decision to charge the applicant is made. As we speak, a decision has been made, a charge sheet is before you. What else are they waiting for? If they cannot take plea. To that extent, Your Honor, if then we are supposed to come back on the 20th before the trial court, the presumption then should be that a decision has not been made and that these orders have not lapsed. So that then our client is still admitted to bail and bond. Number two, Your Honor, if that option is not available to us, we propose that under Article 49, that our client be admitted to bail or bond of reasonable terms, as it is indicated in the file. There, the co-accused were granted bail of 50,000 and bond of 100,000 shillings, pending a charge. As it is now, our client is not under arrest. We voluntarily appeared before you, not even subject to a summons. We only appeared to you subject to a communique that was done in rem. And as a responsible citizen, he decides to comply. Your Honor, we submit that we have not short-circuited any process, and that the DCI, with good collaboration of our good sister, the DPP, decided to charge our client before processing. They put it in order. The only available option is for the DPP to put a nolle prosecute on this matter, so that then they can commence the whole process of processing the suspects and then present them before you for plea taking. Otherwise, we have no obligation in respect to this particular charge to appear before the DCI for any questioning, for any purpose, because a charge has already been preferred before you and as well put by my brother and friend, Mr. Biko. Our client is the property of this court. We are only waiting for the evidence in respect to this particular charge from the DCI and the DPP to be presented before you, so that we can then subsequently therein mount our defense. So, Your Honor, I have made those three proposals. The first proposal is that you tell us the import and interpretation of that. Number 8. The second proposal, that he be admitted to bail pending plea taking if the plea is deferred. Number 3, that a nolle prosecute is the only thing that can save the sinking ship. Most obliged. You know, I'm very sure you don't have a copy of this order. I'll be willing to share this copy. I'm also aware, Your Honor, you will not privy to the communique. Your Honor, will you all be willing to share the copy of the communique?
So this court been appealed court for portion 8 and the directions issued on 19th of May 2023. The file has been moved to court. Court 9 is in the full court. Trial court 8 is out of court on official duties. Court has gone through the orders issued on 19th of May 2023. Same orders is that mention of the matter before the trial court will be on 20th of June 2023 for plea taking. Same orders still stand. For there is no reason this is a complete file and accused person to appear in court as directed on 20th of June 2023, or counsel can, for the accused person, can move court from next week. That is from 20th of May 2023 when court date will be set. So I cannot issue.
I appreciate your findings, and I can see you've also fend off, but you've not assisted us to interpret the import of once a decision to charge is made, what is the fate of our client? Because now a decision has been made, and we understand the DCI wants to arrest our client. So how do we protect the rights of our client? Because a decision has been made. Now that interpretation, if you only don't assist us, will be abused by the DCI, and that's why you can see it's seated before you this afternoon. So,
if I may interject.
We so beseech that you tell us, what do we do with the intervening factor? Because a decision has been made. The High Court said once the decision has been made, the order lapses. If you had taken plea your own, I would have moved you to grant us bail as a matter of right. Now we're in limbo. We do not know what to do.
So Council Ndegwa, I've already made my decision. This is a complete file. For taking, just abide by those orders. In case of anything, you guys can move to the High Court for...
And then I want to make a further application right now. With respect to this matter.
Council, I think I have children matters. Let me just like...
I understand. I understand you.
What application do you want to make?
And the reason why you're not making this application is because you have left us at the mercy of individuals who have the history of not respecting the rule of law. Because you've declined to interpret the import of that order. So you're making your application, Your Honor, that urgently, as a matter of urgency, that this application be transmitted to the High Court for supervisory jurisdiction under Article 165 of the Constitution, so that Your Honor will be able to address the judge on that particular issue alone. And the reason why we are seeking that this file be transmitted to the High Court for supervisory jurisdiction is that the court seized of this matter at this time has not or has declined to interpret the import of order number 8 that was issued by the learned judge on the 18th of May in respect to the fate of our client in light of a charge sheet that is before court. Number 2, why we need supervisory jurisdiction exercised, is that the court has not pronounced itself granted the implication of order number 8 as to whether the court can admit our client to bail pending plea that has been deferred to the 20th of June. Number 3, why we need supervisory jurisdiction exercised, that unless this is done, our client will suffer serious prejudice of his violation to right to liberty. And that the DCI will abuse their power. So those are the reasons why Your Honor would beseech you to have this file transmitted to a judge so that we can address him or her on these matters.
So let me just make a decision. This is a protect file counsel for the accused person to remind the accused person and move to the High Court if they seek to have the same done. They are at liberty to do the same. Court cannot pronounce itself on a file of another judicial officer. This is a Court 8 file.
I'm most obliged, Your
You're
Honor.
most obliged.
I'm grateful. Thank you for your time.
Yeah.
And to our colleague Muslim, the DCI. We are gracious enough to have been accommodated from the start to the end. And we'll see how to span it out with other discussion about this. And so we can deal going forward.
You're most obliged, Your Honor.
So we take a 10 minutes break. People are here.